It is now my great pleasure to introduce our keynote speaker and honorary degree recipient, Nicholas Hayson. Nicholas is a South African lawyer and diplomat who has focused his career on democratic governance, constitutional and electoral reforms, and peacemaking. He currently serves as Special Advisor on Sudan to the United Nations Secretary General. Nicholas began his life's work as a student leader in the 1970s. As a result of his activism, the South African apartheid government detained him and placed him under house arrest for periods of time over several years. After earning his law degree, Nicholas helped found a prominent human rights law firm and became a researcher and later an associate professor of law at Wits University in Johannesburg, South Africa. In 1994, he joined the office of President Nelson Mandela, where he served until 1999 as senior legal advisor. In that role, he advised President Mandela on the implementation of a new rights-based constitutional order. President Mandela's judgment was critical in stabilizing the nation and preserving an independent judiciary. Later in his career, Nicholas advised on constitutional reform initiatives and peace processes in Africa and Asia. He then joined the UN as head of its Office of Constitutional Support in Baghdad. His other positions at the UN have included political director in the Office of the Secretary General and head of the UN mission in Afghanistan. While serving as the special envoy of the Secretary General to Sudan and South Sudan, Nicholas was tasked with revitalizing a peace agreement between the two main rival parties in South Sudan. He was then appointed head of the UN mission in Somalia. After seeking an investigation into alleged human rights abuses by Somali security forces, he was expelled from the country just this past January. He then assumed his current role. Nicholas's career has demonstrated how lawyers can help forge peace and uphold the rule of law even when faced with entrenched and long-standing conflicts. We're immensely proud to present him with an honorary Doctor of Laws degree from New York Law School. Nicholas, would you please join me at the podium? Bill?
We'll give this to you, and then you get it back in the
Thank you. What do I do?
Chairperson Abbey, Dean Crowell, faculty members of the New York Law School, fellow honorees, Virginia and Meke, graduands, guests, ladies and gentlemen. I am truly humbled and honored to be asked to deliver this year's New York Law School commencement address and to be awarded an honorary degree by this long-standing and greatly respected institution, respected both for its teaching and its scholarship. Let me start by firstly registering our collective loss occasioned by the recent passing of Professor Stephen Ellman, scholar, friend, and humanist, and a distinguished member of this community. He will be missed. Secondly, right at the outset, let me congratulate all of those who will shortly receive their degrees. You will today pass this academic finishing line, but not, I hope, bring an end to an enduring intellectual engagement with the law. For me, this event begged the question as to the differences in the world of work and career that you are facing compared to that I faced upon graduating. And there are many differences. For those of you who will go lawyering, it is a far more competitive world. You will, sociologists tell us, change jobs and careers more often than my generation. You'll work in a more flexible environment or even from home. Performance, rather than obedience to workplace culture, will count for more. In a context where knowledge is ubiquitously accessible through the internet, your imagination, your use of information will be more important than the law case citations that you can remember. In this more challenging world, you will rely on judgment and your values, your sense of justice to guide and drive you. In my case, I was immediately confronted by the imperative to take sides against racism and injustice. It was not a hard choice, given that the systematic assault on the dignity of Black South Africans was visible, daily, and up close. But values will always be a part of the rewards, the remuneration, as it were, of a law-affiliated profession. What I would wish for you, all of you, is that your career and your work will be its own reward, as it has been for me. I'm reminded of the tongue-in-cheek advice to Harvard University given by William Kunstler, a colourful and controversial civil rights lawyer, then being awarded an honorary degree on account of his work defending the rights of Californian farm workers. It wasn't civil rights lawyers, he said, that needed recognition and encouragement. They undertook meaningful litigation, worked with grateful and interesting clients. They awoke in the morning with a lust for work. Rather, he said, corporate lawyers needed encouragement and recognition. They worked at the call of no special cause other than the enrichment of their clients who, he claimed, were dull and ungrateful. The issues on which they labored were of little social impact or importance. They deserved to receive whatever honors were available if they survived the brutal working hours of the corporate law firm. I recount this only to draw attention to the fact that there is career satisfaction to be gained from serving the values which make the world a better place. Most of us gathered here this afternoon are associated in one way or another with the business of rules, improving them, amending them, removing them, litigating under them, or bringing them into play, but always making them a more effective way of living together. And of these, the most critical for us to serve and strengthen are those related to rule of law institutions that govern public life, ensure accountability, and constrain public and private power. It's disquieting to note the regression everywhere, both domestically in the country and internationally, on the value placed on managing conflict through commonly agreed rules. While this may relate to a wide range of topics, including more recently trade, immigration, support for multilateral institutions, as pointed out by my fellow honorees, nowhere is this more evident than in the world's headlong dash towards an environmental catastrophe and in its seeming inability to manage its stewardship of the planet. I should confess that when I graduated, I was a law skeptic. Law was the source of the problem, reflecting, even reinforcing asymmetrical power relations. What was to lead to a reassessment of my skepticism towards the law was my experience as a human rights lawyer in South Africa, where, despite the disenfranchisement of Black South Africans and their subjection to systemic racism that governed that country, the vigorous use of the courts in defense of assembly, expression, labor, and organizational rights, alongside political mobilization, allowed those denied their rights to eventually demand and claim them. The courts allowed a particular form of accountability denied by the political process. It allowed those denied political representation to demand equal status in a court of law, a paradox noted by no less than Professor Stephen Ellman. To use but one example, we found an arcane patent law remedy that was intended to preserve evidence where there had been a violation of patent law rights by searching the premises of a commercial competitor without notice. It was this remedy that we used to search a police station by surprise to attach torture equipment routinely used there. It would eventually be no accident that the South African settlement would amount to an agreement to allow and to grant majoritarian democracy against a promise of equality backed up by a Bill of Rights and strong legal institutions. My mentor, Nelson Mandela, would come to play an important role in making this work. His leadership on reinforcing the rule of law was critical. When early in his presidency, one of his proclamations, his edicts, was struck down by the courts for want of respect for the separation of powers doctrine, he leapt to the defense of the mainly white judiciary who had ruled against him, heading off a racially charged political challenge to the very role of the courts. When he had doubts about the constitutionality of one of his own party's recently approved laws, he himself referred it to the Constitutional Court. He told the court that as president, he was a guardian of the Constitution, which role was more important than that of being the head of the governing party. Yet another example was his insistence on testifying in open court and being cross-examined at length on the exercise of a presidential discretion. I know of no other case in a democratic country where a sitting president has submitted to this. As his advisor, I received both criticism and praise for this decision. But in truth, it was his decision and against my advice. Mandela insisted on the importance of demonstrating the legal accountability of even the president, especially the president. If political leadership is critical for entrenching the rule of law, so are robust, resilient legal institutions. In 2000, I was asked to advise on a peace agreement in Burundi in Central Africa. Like a general offering his last successful battlefield strategy, I offered the South African recipe, a Bill of Rights and a promise of equal treatment regardless of ethnicity. It was greeted by the minority Tutsi parties with derision, rightly so. Burundi simply didn't have the robust legal institutions which could protect communities from genocide, either by the armed forces or by any other force. And a country which has endured genocidal massacres previously was not going to trust in the rule of law on the basis of the mediator's promises. The peace agreement would have to rely on a balance of power before it could rely on rule of law institutions. And I learned that one country's remedy cannot be applied to another. In 2011, the World Bank published its definitive study on dealing with post-conflict societies. It showed that states emerging from conflict were the ones most likely to relapse into conflict. In answering the question as to how to break the cycle of violence, it concluded with 3 requirements for stabilization: jobs, safety and security, and the building of rule of law institutions. The tough revelation was that independent institutions are not quick fixes. They can't truly be created short of 20 years, and rule of law institutions with an independent and legal culture can take 40 years. In short, legal institutions are the first to go in civil war situations and the last to re-establish themselves. They remain fragile through the intervening years. How fragile they are is evident even in established democracies like this one, once their functions are contested in a highly partisan manner and lacking in public support. Let me fast forward across my engagements in conflict settings in Asia and Africa. Here, my particular concern has been in the making of constitutions as new social contracts which correspond to the needs of societies that are bitterly divided along identity lines being religion, language, and ethnicity. These contracts have to manage the need for joint rulemaking, creating inclusive constitutions that recognize yet bind diverse groups, making manifest their common destiny without suppressing the differences between them, and always providing for an equitable distribution of economic and political rewards across those fault lines. This is as true for Iraq as it was in Sri Lanka, in Sudan, in Nepal, or Afghanistan. But it is my conviction that citizens everywhere have the capacity to fashion arrangements by which they can live together in peace and harmony. They are limited in this endeavor only by their imaginations, which are often held hostage by their history and their cultural narratives. Of the countries currently wrestling with the task of rebuilding an authentic social contract, let me only share one case of special concern. Sudan, as it is much on my mind, having spent the last 2 weeks myself in Khartoum. Prompted by rapidly deteriorating economic circumstances, after some 4 months of demonstrations across Sudan, and provoked into action by a massive million-person sit-in in front of the military headquarters, on the 11th of April, the Sudanese armed forces removed President Omar al-Bashir. Up until then, Bashir had ruled Sudan autocratically for some 30 years after seizing power in a coup d'etat. The military has not, however, installed a civilian government and up till now continues to govern Sudan in the interests of what they call an orderly transition, enjoying some support from neighbors who have reason to fear the precedent of a subject people who suddenly, taking destiny into their own hands, insist on a democratic transition. The African Union has since declared the military takeover an unconstitutional change of government and has given the Military Council 2 months to transfer power to a civilian authority. On Thursday, the negotiations for such a transfer broke down after attacks on the protesters by uniformed members of the armed forces, leaving the country in a tense standoff. On Friday, the US State Department issued a statement in support of a transfer to civilian authority. And this followed an equally clear statement by a bipartisan group of US congresspersons. And today, the negotiations resumed. Ladies and gentlemen, the fate of Sudan matters. It matters to the Sudanese who've endured military rule and internal conflict almost unabated since 1964. It matters to the volatile Horn of Africa region, and it must matter to us here far away from Sudan. It seems clear to me that many of the issues I've raised in regard to very dissimilar countries, building respect for rule of law institutions, strengthening checks and balances, inclusive approaches to constitutions and constitution making, the management of diversity and political leadership on these questions, have a resonance in many developed countries. One relevant example comes to mind. Over 25 years ago, I and Professor Stephen Ellman debated how a future democratic South Africa should treat states of emergency in its constitution so as to discipline against its improper usage, that is, for purposes that are not really related to a threat to the nation. It was with some irony that this year, when I and the professor met again, that issue should now be of greater relevance here in the USA than it is in South Africa. And thus, I conclude my speech by unambiguously attempting to recruit you, whatever precise careers you follow, to the cause of promoting the values which inform and sustain the rule of law, here and everywhere, and to ensure that those rules are applied in a manner which serves justice. You are, after all, as from today, the newest stewards of those values. I thank you.
Thank you for those extraordinary remarks, Nicholas, and thank you and your fellow honorees for all your amazing public service. It is greatly appreciated by all of us.